At the cornerstone of our criminal defense system is the fact that everyone is entitled to a defense when they're charged with a crime. If they're innocent, they're sort of guilty, quasi-guilty, guilty as hell. I mean, they're still entitled to a defense. I believe in our criminal justice system. You have a right to be tried by a jury of your peers. I always thought that was pretty funny because in Gwinnett County, all I get is a jury of middle-aged Republicans, and I'm looking for a jury of dopers. And then, unfortunately, when you get caught for dope, you lose your voting rights. Therefore, you're not on the jury list. Therefore, I never have a jury of my peers. But I've learned to live with that fact and live with the situation that I'm going to have to try and convince 12 people who are basically conservative, basically pro-God and country, and basically against crime that my client deserves, if not an excuse or an exoneration, at least some consideration in how the case is handled. The reason I went into trial practice, and when I'm introduced to people, they'll say, what do you do? I'll say, well, I'm a trial lawyer. And that may sound sort of redundant, or why do you have to say that? Well, there's lots of different kinds of lawyers. There's civil lawyers that deal in corporate work, deal in real estate, deal in transactional cases. You know, and to a certain extent, that's a fine profession, but I don't think that's what I understood lawyers to be. When I was growing up, you know, we had black and white television. There was 3 channels, you know, and Perry Mason was on every Friday. And I liked Perry Mason. I mean, he was a good-looking guy, had a great-looking secretary. Money was no object. He never lost a case, had the big cars and everything. I thought, this is what I want to be. So I started out going to college at Emory University, and I was going to be a history major. And about halfway through college, I thought, what the heck am I doing? Am I going to be teaching history? So anyways, long story short, I got into business, and I barely scraped through Emory. Emory back at that time was a 4-day-a-week college. The year before I went there, 2 students hung themselves, and they decided the stressors in Emory were too much, so we had classes Monday, Tuesday, then we had Wonderful Wednesday, then we had Thursday and Friday. Well, what it made was Tuesday night was a weekend, and Friday night was a weekend. It was very difficult to stay in school. But I managed to get through school and eke into Mercer University because my father was involved in business management at the University of Tampa, and some of his cronies were at Mercer University, and I got there. And I decided that I would not let that be a problem again. So finally, I put the pedal to the metal, and I think when it was all said and done, I graduated 12th out of 88 while working 30 hours a week in a lawyer's office, learning how to practice my skills, starting the last semester of my first year. And as a result of that, I tell people this, and it is actually the truth. I found out I passed the bar on a Thursday. I graduated from law school on Saturday. I got married to my first wife, QFD1, Queen for a Day, number 1, and graduated, got married on Sunday and opened my office on Monday. I've never worked for anybody else, and there's been some tight times where I had no money, no prospect of money, no hope for money. But after 31 years and working very hard, I've been very successful at it. But the reason I really went into that is because trial litigation is really what being a lawyer is all about in my mind. It's combat. It's winner take all. Second place is first loser. It's mano a mano. You can't excuse your actions. If you win, it's your victory. If you lose, it's your loss. And what I tell a lot of young lawyers when they go into practice is, hey, don't get overly excited about your successes. Don't get overly despondent about your failures, because if you're in this line of work, you're going to see both. I have stolen victory from the jaws of defeat, and I have given away cases too. And I've had cases stolen from me by the jury. Last week I had a very difficult drug case, 2 pounds of methamphetamine being transferred to the local narcotics agents, all on videotape. My client was not one of the actual participants, but he happened to be in the parking lot. The problem became when his cousin came in to testify. His cousin came in to testify and said, yes, I know I was the one delivering these drugs, but that man right over there, Mr. Sanchez Penaloza, is the man that did this. So I thought I had at least a fairly decent chance with this jury I picked. I thought it was a good jury. So after about 6 hours, they were deadlocked 9-3. And I thought, well, that's not too bad. They're not going to convict me, and I have a second chance. Therefore, I may be able to go back and negotiate a better case. I may be able to get the case working a little better for the second time. And it got to be about 5 o'clock. And I said, Judge, I think we need to declare a mistrial, send the jury home, and we'll try it again. He says, no. I think they'll arrive at a verdict. So at 5 o'clock, they're stuck 9-3, hopelessly hung. Nobody's going to move. And at 6 o'clock, they all went home for dinner, and my client went to jail for 25 years. Now, that didn't do much for me. It wasn't the 9 people that voted against me that really irritated me. It was the 3 that wanted to go home and wouldn't stand up for their beliefs and wouldn't stand up for the rights of my defendant. What is being a criminal trial lawyer all about? It's able to get up every day, to go to work, to zealously and skillfully represent a person charged with a crime, no matter how reprehensible you consider the charges. I have had, I think it's fair to say, some of the most outrageous cases that are ever prosecuted around here. Molestations, you name it. And it's very hard sometimes to get past the facts that you find the acts reprehensible. I mean, just like, God, what a lousy piece of scum. Why am I representing this guy? But you have to remember that the cornerstone of our system is that you're entitled to a defense. You have to be able to get up there, to look at the case, and to advocate your client's position as if he could advocate it if he were skilled in trial law. You know, we're subject to considerable scrutiny as lawyers. We're subject to bar constraints and ethics and requirements. And all lawyers are required to be honorable and ethical and to do the best for their client. Not like any profession. We have a few rogues. We have a few bad eggs in our profession that take advantage of people. But all in all, most of the people that devote themselves to trial practice are honest and have a considerable amount of integrity. You know, the criminal justice system has changed in the last couple of years, and I don't know if I benefit or I suffer a detriment from all of these law shows, CSI, Law and Order, you name it. I mean, you can watch it 24 hours a day if you're so inclined. I generally watch it for an hour or two a night just to see if there's any new little tricks of the trade that I can glean from watching this. What I really do enjoy, though, is CSI, because that's obviously cutting-edge technology, and it's very interesting. And a lot of times I'll find various issues to raise in defense of my clients from those shows. But those are 1-hour television shows where you have to have first the crime, then oh my God, can you believe this actually happened? Then you have to have about 15 minutes of thorough investigation, interview 20 witnesses, blah, 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 blah. You have to try them, you have to have all of that. And in 1 hour he goes from no crime to committing a crime to trial to conviction, and everybody goes home happy. Well, unfortunately, that's not quite the way it works in the real world. A significant case such as a murder case or a big drug case might take a year, now sometimes up to 2 years between the time it actually occurs and the time you go to trial. In the criminal justice system, and that comes off Law and Order, there are two entities here, the police officers that arrest and the prosecutors that prosecute. And I always want to, and at the end of that it goes, and the defense lawyers that get them off. But anyways, that's not on the TV, but you know, that's the way I handled it. But basically, prosecutors and defense lawyers are the same type of people. They're skilled in the law. There are a few minor exceptions. I believe the defense lawyers are generally the product of a natural birth with loving music and have a different attitude about life. I believe the prosecutors are breech-born and dropped on their heads. And that's the reason that they have problems most of their life. And that's the reason that you see a different attitude among prosecutors and among defense lawyers. I always find it interesting. After a while, you see a lot of prosecutors will get their experience trying cases. They'll try cases 3 or 4 years, and then they'll go off and be a defense lawyer because that's where the money is. The other ones that really get me, though, are if you're a defense lawyer and then you become a prosecutor. I don't know how you really go from that side of the table to the other. Occasionally that happens. But generally, your prosecutors are very straight-laced, conservative, work a hard 9-to-5 job, get a Friday paycheck, and enjoy the government benefits, and that's what they want out of life. On the other side, there's the defense lawyers that are the former hippies, the Harley riders, libertarians, use 12-hour days, and if you make it, you take it, and if you don't, you starve. And it's a basic ideology that's the difference between prosecutors and defense lawyers. For whatever reason, I was made a defense lawyer. I guess because of my nature and the way I handle cases and my aggressive, building the China shop sort of attitude about things. I'm lucky I was born with the physical stature I have. I'd hate to have my mouth and my attitude to be 5'8", 150 pounds. It's just not working. 6'5" and 275 seems to carry on. I'm going to give you a difference about cases and how cases are handled. I had a drug case a while back. A Mexican guy got caught, well, two American guys got caught delivering 1 kilo of 98% pure cocaine to undercover agents. And I thought, I was like, 98% pure cocaine. I got to go see this. So I went over to the evidence room to look at it, and it looked like a bag of snowflakes. I thought, that's really interesting. So we tried this case, and I was against a prosecutor by the name of Dan Mayfield, who's an excellent prosecutor, former police officer, God in the country. I mean, this guy is straight down the line. It's a very, very hard-fought case. The two co-defendants rolled on him. The state said that we have absolutely no agreements with them for their cooperation. We have reached no agreement with them. There is no deal. That's what they call it, the deal. Had you got a deal to testify on that day? So I made a big argument and showed case histories where there was what I call the no-deal deal. That means we have no deal with you, but if you come up and testify this week and help us get the person we want, everything's going to be wonderful and everything will go. But they swore to God there was no deal here. I asked them on the record, do you have an agreement? Are you going to plead guilty to trafficking cocaine? Yes. Are you going to take your 20 years? Yes. Are you going to take your 300? I know I will. So anyways, they denied that. Well, as fate had it, the jury found him guilty. But during the trial, there was a funny moment. At the end of every day, Mr. Mayfield would stand up and say, Your Honor, the state will take possession of the contraband and ensure that it's returned to the courtroom for further trial proceedings in the morning. So after he did that a couple of times, the third day I got up and I said, Your Honor, I too am an officer of the court, and Mr. Mayfield has gotten to take the cocaine home for the last 2 nights. And I would like the opportunity to take it home. I, as an officer of the court, will return it to you in the morning. And Deborah Turner, who I love to death, who's a Superior Court judge and used to be a prosecutor and is a longtime friend of mine, said, Mr. Sliz, I appreciate your offering that, but I just don't think I would get back a kilo of cocaine in the morning. So everybody in the courtroom laughed, and I said, au contraire, Your Honor. If you will give me that kilo of cocaine, I will bring you 2 kilos of cocaine in the morning. She said, oh, no, Mr. Sliz, not. So he sat down and said, Your Honor, may I approach? So I walked up to her. Now, you can't do this with every job, but after 30 years, and I'm older than almost all the judges, and I've worked with them, and we've been friends forever, so I get away with a whole lot of things that younger lawyers don't. I walked up and said, Your Honor, if that's what cocaine is supposed to look like, I've been screwed. She says, Mr. Sliz, sit down and get back to defending. Thank you, Your Honor. So I went back to defend it. So they convict him. Well, when it's all said and done, he hires a new lawyer because during the whole course of this, he didn't want to think about entering a plea, even though there was significant evidence. And I knew that they had a similar transaction, but they were very slow in giving me the information on what the similar transaction is. And the similar transaction is they caught you doing something else before, and because it shows your common scheme, mode, or bent of mind, or your modus operandi, they introduce that as evidence. And the ha-has, they say, you're not supposed to consider it as evidence in this case, just his attitude. Oh, come on, please. You're just putting his record in and you're saying he's a doper and you need to convict him again. But anyways, so he didn't bother to tell me. I knew he had had a conviction, a federal conviction where he was caught for sale of cocaine. Well, he didn't bother to tell me, and he talked around it. Well, they give us an offer of 20 serve 10. In this case, has a possibility of life in prison. So he says, no, I'm just not doing that. I can't do that, blah, 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 blah. So I reject the plea offer, and they withdraw the plea offer. Well, about a week after the plea offer is withdrawn, I get the information on the similar transaction. And it is a sale of cocaine to federal undercover agents 3 years before at the same restaurant that this took place at. And I looked at it, and I looked at him, and I said, we have major problems. So anyways, we tried this case for 3 or 4 days, and the jury found him guilty of it, and the judge gave him life. Well, Jesus, he said, I want that 10-year plea. He's tapping me on the shoulder. I want that 10-year plea, and I'm saying, day late, dollar short. Anyway, so they file a motion for new trial, claiming ineffective assistance of counsel because I never told him he could get life in prison. And it was very funny because I'd done him a little chart that showed, weights of drugs and, number of convictions and what you could get, 20 to serve 10. I'm trying to sell him on a possible plea here. But somehow it disappears over off the side of the page before it gets to life in prison. And he swears to God I never told him he could get life in prison. So we get to court, and he's filed a motion for new trial claiming my ineffective assistance of counsel because I have not told him he can do life in prison. And to be honest with you, I can't remember if I did or I didn't. And so here I am, where Dan Mayfield's beating me to death while I'm in trial with him. He is now telling, now you're an excellent trial lawyer. You've been there 30 years, and you would have told him that he could get life. And then the defense lawyer is calling me everything except a white boy, and she's telling me, you were ineffective, you didn't tell him, and he's entitled to this and all that. And at this point in time, I really don't have a dog in the fight. It's no longer my case, and I don't care. And I honestly can't tell him if I did or I didn't, but I figure, let's err on the side of caution. I forgot to tell him. So we get up there, and we're starting to talk about this no-deal deal with the judge. And by that time, the two people that had no deal had their charges reduced from trafficking and a $250,000 fine to mere possession, a $1,000 fine, and both had been let out of jail. But there was no deal. So we got into it, and I turned, and she asked me, the defense lawyer asked me something about this no-deal deal. And I said, well, you know that, Your Honor. And I turned to the judge who was sitting about 4 feet from me. I'm on the stand. I said, you remember this was that no-deal case. And then afterwards, the state dropped the charges of trafficking and allowed them to plead to mere possession of drugs. And you gave them, I think, let's see, Judge, I think you gave, one got 2 weeks no playground. The other one got 3 hours in a corner and no cookies. And she is just burning. She's so mad. And I'm just trying to keep the 4 feet between she and I. But I'm telling her, I told you this was going to happen. You knew it was going to happen. Now it's happened. La-di-da. So anyways, that night, about 9 o'clock at night, I get this phone call. Phone rings. I pick it up. Jeffrey? Yes. Deborah. Oh, hello, Deborah. How are you? I just want you to know I granted the motion for new trial on general grounds. Your client accepted 20, served 15. Don't ask for any other favors. Down goes the phone. So anyways, that is really the life and times of being a criminal trial lawyer. It really is combat. You never know, literally from the moment you start to the moment you're done, as to whether or not you're going to win the case or lose the case. These handouts that I gave you, I'm going to go quickly through them because you can read them. But the first one that I gave you and is in there, and we'll get some more if you need it, is this criminal interview questionnaire. And it's pretty factual. And I ask all of my clients to fill this out and, put down what you were charged with, were there any witnesses present, who arrested you, what amount of drugs did you have, or what occurred, did you make any statements to police, are there any co-defendants? It's a factual thing. And the first thing I tell my clients is, I don't care what the truth is. And I really don't, because I am going to defend them regardless of what the evidence is, okay? But I want to know the truth, because nothing makes me madder than to get halfway through a case relying on what my client has told me happened and all of a sudden realize he's lied to me and I've wasted hours and hours of preparing the case and investigating the case and researching the case. So I ask them to fill out this questionnaire, and then I go through it with them. And if I don't think their story passes muster with me, I therefore know it will not pass muster with a jury. And so I say, okay, I'm going out the room, then we're going to come back and have this conversation about telling me the truth. Because I really don't want to try and defend you if I don't believe you. So some lawyers choose not to know, and they like to go blindly through life. I choose to know. It is not my job to tell the prosecution how to try the case or to prove their case, just to defend my client. I give what I call a letter to criminal clients, which is here, and it basically is just an outline of the criminal procedure, how cases handled from the date of arrest through the drawing of an accusation, preliminary hearings, bond matters, and then get back to the last page that is most dear to my heart, and that is payment of fees and bitching and moaning. And that's what it says. And it basically says, I will be your lawyer as long as you are paying me the fees that we've agreed on. And I am not the highest priced lawyer out there, and I tend to take lesser fees if I want to handle the case. And by wanting to handle the case, I mean if it's a case where I feel I can do something for my client. I mean, if there's 6 eyewitnesses, confessions, DNA, blood splatter evidence, and he's got the gun in his pocket, all I'm doing is holding his hand. But if it's a case where I think that my skills and my abilities can help him, then I'll sometimes cut my fees just to be able to handle that case. But this here basically says that I want you to pay me the money, and under bitching and moaning it says, I don't take bitching and moaning. I have several hundred cases. I literally don't have time. I will represent you to the best of my abilities. I will fight hard for you, but don't whine. I didn't put you in this position. I'm trying to get you out of it. And you'd be surprised how many times I have lawyers call and said, I saw this letter the other day. Do you mind if I send it to my clients? I said, I really don't care. Anything that I learn in law, I give to my fellow lawyers. I speak at seminars. I wrote for the Gwinnett County bar paper the other day, and I came up with 24 different ways to attack a search warrant, and I gave it to all of them. Because what I learned, I'll give to my fellow lawyers. And because it's like a brotherhood. Everyone helps themselves as criminal defense lawyers. We have a very strong Georgia Association of Criminal Defense Lawyers. When I joined in 1976, I think they had 30 members. Now there's 1,500 members. But we have seminars 4 times a year. We have web pages. We're really cutting edge. And in fact, it's been used as the guideline for establishing most of the criminal defense bars in this country. The third thing I put in there was what are called jury charges. A criminal case is based on two factors. One are the facts of the case, and the second are the charges of law. And generally, the judge is going to read charges, and first thing he'll do is read an indictment. Then he'll tell the jury that that neither the Indictment nor the plea of innocence is evidence. That's only the means for bringing the case into court. He'll charge on the one sheet that I think I gave you, and that's the basic tenets of criminal law, and that is the presumption of innocence. Presumption of innocence, burden of proof, and the definition of reasonable doubt. I don't have to prove the client innocent. I just have to show that there's reasonable doubt that he's guilty. And it says here, the state is not required to prove the guilt of the accused beyond all doubt to a mathematical certainty. A reasonable doubt means just what it says. A reasonable doubt is the doubt of a fair-minded, impartial juror honestly seeking the truth. A reasonable doubt is a doubt based upon common sense and reason. It does not mean a vague or arbitrary doubt, but is a doubt for which a reason can be given, arising from a consideration of the evidence, a lack of the evidence, or a conflict in the evidence. After giving consideration to all facts and circumstances of the case, if your minds are wavering, unsatisfied, unsettled, then that is the doubt of the law, and you should acquit. But if that doubt does not exist in your minds as to the guilt of the accused, then you would be authorized to convict. That's the criteria the juries have to use in establishing the guilt or innocence of a defendant. And it sounds like it's a little amorphous, a little vague, and it really is, because what might be reasonable doubt to one jury may not be reasonable doubt to another. The next thing I gave you are just voir dire questions. And what these are, voir dire is the jury selection process. It's how you pick a jury. And first you have to understand that there are lots of books, videos, seminars on jury selection, and it is all crap. Jury selection is at best a beauty contest. I'm looking at you, you're looking at me. I'm trying to decide if you look like you're conservative or you're liberal. I'm trying to decide if you might have a stake in this case. You may not like my Mexican client. I might try and find out what you're all about. Now, you're supposed to pick a jury in most cases in 3 or 4 hours. Well, if you divide the 40 or so members of the jury into 3 or 4 hours, you're getting to spend about 5 or 6 minutes with a juror. Now, what do you think you're going to know after 5 or 6 minutes? Sip. So I sometimes tell the jurors, you know, this is at best a beauty contest. You're looking at me, I'm looking at you. I'm trying to decide if you're fair and impartial. You're trying to decide if you like my tie. You know, that's all it is. But all I'll ask you is what I call the $64,000 question. And that is, do any of you have any reason whatsoever that we haven't discussed which you feel might make you less than a fair and impartial juror? And most of the time you get 2 or 3 people say, you know, I tried to be fair, but I don't like anything about your client. He looks guilty as hell, and I would convict him before I hear the first piece of evidence. Well, that's fine. At least you get those off. Most of the time they sit there and go, I'm not going to say anything, and I can't wait to get to the jury room, and your client's gone away for 20 years. They just don't tell the truth. So you find yourself having to work with what you have to work with. Those are the voir dire questions. This is just simply a chart that I make up. Puts down everybody's names and little catchphrases. Do like, don't like, look stupid, too smart, too sarcastic, too this, too that. And then I say yes, no, and we pick. And basically, the state throws out all the liberal people that they think would align with the defense. The defense throws out all of the conservative people, those people that have families full of police officers, you know, things that you think just would probably impact or impair them to testify. And when it's all said and done, you got 12 people up there, and you really don't know what you have till the case is over. The last thing I did and handed out to you is what I call the continuum of innocence. And this is my humble attempt at trying to explain the basis of guilt and innocence to a jury. And it starts off on the left-hand side with innocent and goes all the way to the right-hand side with guilty. And then at the top it says burden of proof, evidence to convict. And then I tell them that you cannot convict, you are not authorized to convict, unless and until the state has proven their case beyond a reasonable doubt. Then I say that a defendant is entitled to a presumption of innocence. That presumption of innocence stays with him unless and until you find evidence sufficient to prove the man's guilt beyond a reasonable doubt. And then I do duty to acquit. You have a duty. You don't have to like it. You don't have to be proud of yourself. You can sign a different name. I could care. But you have a duty to acquit unless and until the state proves their case. And then what I do is if there are certain charges of law that I think are important, I'll put them down here just as a little reminder. This was that drug case where my client's cousin did him. And so he got, instead of getting 25 he should have got, he's getting 15, and my client's getting the 25. What's funny about that is when it's all said and done, they're both going to be deported and both go back to the same village in Mexico. It's going to be a tough Sunday. But anyways, I put down what's called mere presence. Mere presence says, mere presence at the scene of a crime is not sufficient to convict without other independent evidence. Mere association. Mere association means that if I merely associate with people that violate the law, that does not make me guilty. And then circumstantial evidence. And then I tell the jury what those are. Then I talk to them. This case was a question of what was a party to a crime. Was he really involved in this case, although he didn't have a hands-on role in it? They never saw him with it. He never had any money. But he was there, and this was his family. And what was really bizarre about this case is they keep talking about the drugs going to be delivered in a silver Oldsmobile. Okay. Well, somewhere in the middle of it, the other guy that was involved shows up in a ex-DeKalb County police car where they've taken off the decals, but you can still read DeKalb police. And he goes to deliver the 2 pounds of methamphetamine to the undercover agents in the old DeKalb County police car. I thought that was real interesting. Anyways, jury thought it was kind of interesting, too. What you have here is what I call the carrot. I talked to them about the benefits that the co-defendants were getting. They're willing to say anything in order to save their own rear ends or to at least lessen their sentence. And then the sentence that they were talking about was a 30-year sentence and a $1 million fine. And then I talked about the only way you can get out of trafficking if you have more than 28 grams of cocaine or methamphetamine or crack or other Schedule II drugs is if you provide substantial assistance to the district attorney in the prosecution of the case. So that is the big carrot. Provide substantial assistance and you get less than the other people. And then what I try to close with is, what do you have to have as evidence to convict? Well, it's possible that he was involved. Is that sufficient to convict him? I check no. You know, he's out there. They're all talking. Yes, we didn't see any money transferred. No, we didn't see any drugs transferred. But, you know, it's highly probable that he's involved in this. That is insufficient to convict. Only if you prove him guilty beyond a reasonable doubt. And then I thank them. I say, look, you don't have to like what you're doing, but it is your duty to acquit him if they haven't proven their case. And I sit down and pray quietly to myself, and then we see what happens. But these are just an outline of how a trial goes and how it starts and goes through to the conclusion where the jury comes back and you sit there with bait. I've always had this thing where I cross my fingers. I don't know what it does. Maybe I cross my fingers. Well, maybe I'll win. Half the time I come back with no fingers. Sometimes I win. I want to tell you one thing about jury selection that's very funny. I had a case where this guy was charged with DUI and possession of marijuana. And they had a videotape, and the cop goes up and says, you been smoking marijuana? No, I haven't been smoking marijuana. Well, what's that on your chest? And he looks down and he goes, nothing. So anyway, I knew this was coming. So in jury selection, I'm talking to jurors, and I said, you know, it would be entirely inappropriate for me to ask any of you on the jury panel if you smoke marijuana, because it's really not my business if you do or you don't. But let me ask you this one question. Have you ever been out at a party, sitting at home in a chair, and looked down and happened to see a joint between your first and second fingers? Well, they always go, ha, ha, ha. They all laugh, and about 5 or 6 put up their hands. I think, okay, he hasn't got enough strikes. I'm going to have at least a couple of dopers on this jury. So anyways, we go to trial. I keep a couple, 3 dopers, and they acquit this guy that is just guiltier than hell. I guess it was just, well, I'll do one for the cause. So you will never know when the jury's going to be with you or without you. Anyways, so when you're trying a jury trial, as I told you a minute ago, it's the state's burden to prove the defendant guilty beyond a reasonable doubt. You know, there's an old adage among defense lawyers. Get your money up front. It's his ass, not yours. Get your money up front. That's what you're supposed to remember. Because if you lose, there goes your fee. Okay? People say, well, you know, if you're defending somebody that's guilty as hell, and you know it, how do you do that? Well, the simple fact of the matter is, I attack the state's case. If the state has a strong case, good investigation, strong witnesses, statements from the defendant, I really am only holding the hand and trying to lessen his sentence. On the other hand, if they have an iffy case, if it's dopers robbing dopers, or it's bad people getting into it with bad people, which happens a lot of the time, then there's issues about credibility, believability, which I will work on. But I have been offered money to go talk to the judge. I said, you know, in the age of computers, I just don't think I'm going to do that. Then people will tell me, well, I got a witness. Guy's going to come up and say I was in South Georgia. Well, that's nice. Who's going to be your lawyer? I do not suborn perjury. I do not put up obvious false evidence. I put up my case as best I can. If I have a lot of cases to put up, I put a lot. If I have a little, I put up a little. But if they do their work, then my job is going to be very hard. But things being things, the amount of crime in our society now, the stressors on the prosecutors, the stressors on the police and the investigators, a lot of times T's aren't crossed and I's aren't dotted, and there's issues that come up in the case. The defendant never has a duty to testify as to his own innocence. Oh, yeah, sure. Go in there with a case where you may or may not have been the one that shot somebody. You may or may not have been the one that had the drugs that were in the car, and just sit there quietly and let the judge say, the defendant has no duty to testify, and you cannot draw any adverse consequences from his failure to testify. Oh, yeah, sure. If you can't get your man up or woman up to testify that they did not do it, then you might as well just, go have lunch because the jury will be back quick. And as I tell people when I speak to them, I'm not the judge of the jury in this case. That's not my role. My role is to be an advocate, to advocate my client's position as he or she could if they were trained. What do you need in order to have and to be an effective defense lawyer? You have to have balls of steel. No fear. And the bottom line is, you don't have to win every case. You just have to go in and bludgeon them. I'll tell many a prosecutor, oh, boy, I tell you, by Friday you're going to kill me. I mean, I'm just gone. You're going to whoop me to death. The problem is it's Monday at 9, and you have me for the rest of the week. And I contest every issue, and I make myself, I just assert my client's rights. That's what I say. But anyways, I give them a tough time. And if you cannot win cases, you cannot plead cases. Now, what do I mean by that? If you are not a good trial lawyer, if you can't win the close ones, if you don't win your fair share of high-profile murder cases, rape cases, molestation cases, which I do, then you can't plead a case. Because if they know they can whoop you, they're not going to offer you anything but what they want. And that separates the lawyers that are ready for trial and what we affectionately call ready unless reached. One time I had a case where I was sitting through about a 50 case calendar where they announce all the cases, ready, not ready. Yes, how long, day, da-da-da-da-da. There had been 17 cases, and I was supposed to be 17th. And I got up, and it was Judge Howard Cook, who's since retired, a swell guy. And I said, Judge, I believe I'm third. When should I be prepared to try this case? He looks at me, he looks down his list and goes, no, Mr. Sliz, you're 17th. I said, no, I'm third. And he says, well, we have all these other cases. They say they're ready, la, 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 la. When do you think? And I said, well, Judge, if I am third, when do you think it'll be? Tomorrow morning, tomorrow afternoon? Well, I think it'd be Tuesday afternoon. Well, it actually was Wednesday morning, and I was fourth because everybody else bailed. They got up there, but when it got to the time where they had to get up and defend the client or plead their client, they pled them. Of the 125 or so lawyers that do criminal defense in Gwinnett County, there's no such thing as the best criminal defense lawyer because the facts dictate a lot of what happens in a case, obviously. But there's an upper echelon of criminal defense lawyers. There's probably 15 lawyers out of 125 that try 75 to 80% of the cases. And the rest of the people are just so much lettuce in the salad bowl. They fill out the calendar and they look pretty and they talk like they're lawyers, but they're really counselors at law. You have to be able to think quickly on your feet. I tried a murder case a couple of years ago where my client was accused of shooting this guy over on a dirt road in Tequila. And they were looking for a very unusual truck, an old red on white Ford pickup truck back in like the 1970s. And he became concerned because he had a pickup truck like that. And he thought, they may think that I'm involved in this, so I'm going to go to the police and tell them that I'm not involved. Well, 5 hours that day and 6 hours the next day, he voluntarily went down and talked to the police. And he first said, I don't know nothing about it. I ain't heard nothing about it. Was sitting at home with this. Well, I did go to the QT that day, but I didn't see anything unusual. Well, I did go to the QT, and I did see this guy. And, in fact, the guy that's sort of like that came over and asked me to check on his vehicle. Well, the guy needed me to check on his vehicle, and so we went down this road. And I was checking to see if it had there were some other people out there, and somebody came up and grabbed him out of the car and shot him. No, I guess I got to admit, I really did shoot him, and it's my fault. And no, you forced me to say this, and I've got nothing else to say. I don't want a lawyer. 12 hours. So we go to trial, And I'm thinking, how and what am I going to do with 12 hours of video that goes from I don't know nothing to I did it to I don't know nothing? So anyways, I went with my partner, Scott Drake, and we had mock trial over at the jail. And we spent 2 nights before trial grilling this guy about his what he's going to say. And in that case, I said to myself, he can say whatever he wants because I'm not going to tell him to say anything because, A, I don't know what is the truth here, and I'm sure not going to hear later that my lawyer said to say this or that. So he says what his recitation of the facts are, and we grill him and we get him ready. He's not going to be surprised. He's not going to be nervous. He's going to be battle-hardened when he gets on the stand. So here I am up there in front of this jury, and I start to ask him questions, and I know what he's going to say. And we go in this, and all of a sudden he comes up with the 13th hour version of this thing. And I'm up here, and I'm asking him questions, and my questions are not dovetailing with his answers at all, and I have no idea what he's doing. And I'm sitting there, and I am so mad. I'm thinking, you lousy, sorry sack of crap. I'm standing up here trying to protect your butt, and I don't have any idea what you're fixing to say. And so I quickly got done and sat down. And my ne'er-do-well associate at that time said, great job, great job. I said, we are in deep trouble. So anyways, we went there, and the prosecutor came by during his closing argument, and they had figured out that after the guy left home with $28, had lunch, did this and that, he could not have had more than $7 on him at the time that he was robbed and killed. And the prosecutor came over in his closing argument and put down $7 in front of my client and said, can we have his life back? You see how quiet it is right now? Nothing compared to how quiet it was in that jury room. Well, this was a 2-week trial, 42 witnesses, 137 pieces of physical evidence, and 15 minutes later, my client got life plus 25. You never know what you're going to have when you get in there. I've also won one in 9 minutes, though, so I'm better. I've won one faster than I've lost one. But in order to be a successful trial lawyer, you've got to be creative. Anybody can look at the documents and question a person, well, Mr. Johnson, didn't you in fact say this or that or whatever? La, 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 la. I prepare to approach criminal defense like a relief pitcher. Don't come up and throw strikes at them, throw junk. Throw one at their head, throw one in the dirt, throw a changeup, throw a curve. Never let them know what you're going to do. When I was talking with Jennifer before, she reminded me about a case I tried a long time ago, a murder case, and this had been a fight in a hallway where the victim had a straight razor and my client had a Desert Eagle 38. And he shot over the back of his head, and brains and head went everywhere. So I recreated this entire courtroom, this entire hallway with 2x4s and doors, but I left it open so you could see. And I was the victim, and he wrestled with me, and I fell exactly where I had to fall in order to have my theory of how this occurred happen. And we were doing real good. And then he was on the stand. And at some point in time, I had managed to keep the Harley-Davidson jacket with the brain matter on the sleeve under the table. I'd stayed away from the really touchy parts, and lo and behold, he says to the prosecutor, do you want me to show you how it happened? And I mean, shoo, all my organs just fell and went, oh, God bless me. So he gets up and walks around, gets under the table, brings out the Harley-Davidson jacket with brain matter, puts it on, and gets up with an investigator from the police department, the victim, investigator from the police department. And they go wrestling around in here. He tries to show the jury what he did with his gun and cannot do it. Right in the tank. I'll never forget that because one of the judges down in Walton County, no, not Walton County, Rockdale County, we used to have to get permission to go on vacation. It's called a leave of absence. And the judges had to approve it. Now, if you give them 2 weeks' notice, they don't have an opportunity to disapprove. You can go on your vacation as long as you give them notice. Well, I had this one judge, Sidney Nations, who just refused to sign my leave of absence. And as the week is going on, I know I'm trying to go to the beach at the weekend when I'm done with this case, and I can't get Sidney to approve it. So finally, Thursday afternoon, about 5 o'clock, I hear that Sidney's finally approved that I can go, and I don't have to be in his court the following Monday. So later, case got tried, jury came back and convicted him. I drove part of the way to the beach that night, and I spent that whole first night retrying this murder case in my mind, off and on, all night long. I didn't get any sleep. Get to the beach, go out to the beach. I'm tired. I go to bed early. The next night, I'm dreaming about a murder case, and I wake up about 12 o'clock going, I don't have a case like this. What is this? I don't even have it. The third night, finally, I went to sleep about 4 o'clock in the afternoon, and about 30 hours later, I woke back up. That's the kind of stress and strain that a major case takes on you. But when I got back, I saw Sidney Nations later, and he said, "Oh, Mr. Sliz," and he's real bow tie and horn-rimmed glasses, and he's a piece. Anyways, he said, "Mr. Sliz, what would have happened if I hadn't granted your leave of absence?" And I looked him down, and I said, "We'd have had a hell of a fight when I got back, Your Honor." But anyways, you have to have an attitude and aggressiveness, a desire to compete in order to prevail in cases such as that. One time I did a physical demonstration. There was a guy, 6'1", 200 pounds, long-haired doper over at the mall. Well, I had a client who was very clean cut. He had to wear Docksiders, Izod shirts, penny loafers. He's walking through the mall. Well, this guy starts giving him some crap. And he says, leave me alone, da-da-da-da-da. He says, "Hey, man, I'll take your behind outside and give it a good whipping." My client says, "You really don't want to do that." He says, "Come on, man, what are you, chicken? Come on." My client says, "Okay." So he goes outside, fails to tell him that he is a Golden Gloves boxing champion. So he goes outside, and the scuffle starts, and my client knocks out 2 teeth, breaks his jaw, busts his nose, and beats the snot out of this guy. Well, my client gets arrested for aggravated battery for all the physical damage done, and they bring this guy in. And so when he's coming in, I'm noticing that there's this 5'8" to 6'1" disparity in about 30 pounds. And I got him to come down, and I first asked him, I said, "How long was it from the time you smoked dope to this fight start?" "What do you mean?" I said, "Just what I said. How long was it?" And I'll remind you in a row. "Well, I smoked a joint about an hour before that." I said, "Okay." So I got down, I put him back to back, and he's, like a whole head taller than my client. I went back up, and my closing argument was very simple. This was just a mistake in judgment. The victim decided he was going to whoop butt. The problem is he made a mistake on who he picked. And that was a 9-minute victory. They thought, well, he got what he deserved. Granted, it took him about 6 months to get his face redone, but he never bothered to ask, "Oh, by the way, are you an amateur boxing champion?" And he was. One time I had a child molestation case, and it was a little 5-year-old boy, and his father, this was very ugly, and his father was accused of letting the little boy perform oral sex on him. And they brought out a little table and chairs, and it was a little circular table with little itty-bitty chairs. And the prosecutor, you probably know her, Allie Malden, excellent prosecutor, gets up, and she sits down at the table with this little boy, and they talk. And he says, "Oh, yes," and then Daddy would say, "What a good boy am I." Oh, God, I'm going like this. So it says, "Okay, Mr. Sliz, it's your time for cross-examination." So I go over there, and this kid is sitting there, and he just goes like this. He looks up, and he just puts his head down in his arms like this. And I sit down. I can't get him to move. I can't get him to acknowledge I'm even there at the table. Finally, after 5 minutes, the prosecutor comes up and says, "I don't think he has a lot to say, Mr. Sliz." So anyways, that was a bad day. But you have to come in and use different techniques, different things that come to mind, just to keep the prosecution off guard. But in all, it gets down to preparation, determination. You're going to win the ones you're going to win. You're going to lose some. You're going to lose. But in the whole scheme of things, what you're trying to do is defend your client, to advocate his rights, to make the state prove their case. If they prove the case, they're going to convict him. If they don't prove the case, if they don't have a strong case, then there's an opportunity that he won't get convicted. And in 80% of the cases, that's maybe 20% of the cases that get tried. In 80% of the cases, the strength of the case and the strength of the lawyers dictate the plea offer that will be made. Last couple of things, just some closing thoughts on being an effective criminal lawyer. As I said, you have to be dedicated. You have to be willing to spend the Sunday afternoons, the Monday nights, going out to see witnesses, to view the scene, to prepare your case. I've lost a lot of cases over the years. I've tried hundreds and hundreds. I say a lot. I haven't lost a lot of cases, but I've never been outworked. I've never been underprepared. Because if you're going to be in this business, you're either going to be a good criminal defense lawyer or one of the other many. And I pride myself on my abilities, I pride myself on my work ethic, and I do the best I can for my clients. And as a result of that, I have a very large law practice, and I've been successful. I always go out to talk to the witnesses that are crucial. I always go out to view the scene. The reason I go out to view the scene is sometimes you get up there and if you've never seen the scene of the crime, and you're looking at pictures, you sometimes don't get a real feel for it. But sometimes people will go out there and say, well, I was over there standing on this corner and I saw thus and such. Well, you say to yourself, wait a minute, there's a tree right there. You can't possibly have seen that. So if you know what the scene looks like, if you know what the physical layout looks like, oftentimes it'll help you in your cross-examinations. No one wants to be found guilty, but I tell you what most defendants really want, and that is they just want somebody to fight for them. I mean, I've seen people go back in 20 years and say, I got that 20 years, but man, I really appreciate it. You really whooped their butts, blah, 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 blah. It's all they want is to have somebody care for them, somebody that advocates their interest. People say, well, aren't you fearful of representing these people? I mean, you're talking about murderers. You're talking about rapists and all this. Not really. I'm honest. I charge fair fees. I work like all hell. I have no fear of my clients. I'm not the people that they have it in for or the people that they had problems with. I'm the only difference between them and incarceration. And then I thought I would give you what I'm entitled here, Jeff's Legal Gems. As I told you before, I have a son 20, a son 18, a stepson 18, a stepdaughter 25, and I try to keep them inside the white lines also. And I realize that most of what I say to my children is like right over the top. You just want to sort of put your hand behind and look through their eyes and see if you can see your hand. But anyways, realizing that, and realizing that, you all are going to be tempted to be involved with drugs and alcohol and things such as that. A couple of things. One, if you're ever in a car and you get stopped, never consent to the search of your wallet, your purse, or your car. I don't care if they tell you they're going to haul you behind to jail, you'll never get a bond. I don't care if they say Sniffy the dog is going to come out and they'll find those drugs. Remind me to tell you the drug story in a minute. They'll find the drugs. Never give them consent to search your car. No, sir, I will not. My attorney has told me never to do that. Use the word attorney. I want to talk to my attorney. I need to talk to my attorney. If they say, well, we'd like to question you about this. No, I'd really like to talk to your attorney. Because what did they say? And officer, what did she say when you asked her about telling you about these drugs? She said, I want to speak to my lawyer. Now, that's about as vanilla as it can get. It's not an admission. It's nothing more than I like to assert my rights. I like to talk to counsel. Not that you're not going to love me and treat me wonderfully and take me to jail, but you're obviously not my friend. Second, this may appear real. How many people know what the difference between a misdemeanor marijuana case and a felony marijuana case is? Yeah, what? I know you do. Anybody else know what amount of marijuana is necessary for a felony as opposed to misdemeanor? 1 ounce, 28 grams. I'm always wondering, why don't they sell bags with 26 grams? It's a misdemeanor. There's a considerable amount of difference in your future between a misdemeanor charge and a felony. So, 26 grams, not more than 1 ounce. Hey, you may have gotten a great deal. You got 30 grams instead of 28. It's just another 6 weeks in jail. Never carry more than 1 ounce of dope. Okay? Do I make myself clear? I mean, that's a pretty easy one. But if, and I'm not stupid, I can look around here and I don't see my sons, but I see other people that look like my sons. One of them crashed one day, so I go over to the scene. The car's up on its roof. I'm looking around. He's sort of beat up, but he's okay. Apparently the tie rod broke, and he took it into the trees and it landed on its roof. And all the police officers are walking around, and I'm talking to them. I know most of them. I'm walking around. I'm picking up my kid's change and all this other stuff, and here's a hitter. I look at it and go, oh, this is good. So I walk over to my son. I said, let's cut to the chase. Don't bother humoring me. Where's the marijuana? It's in the bag. Okay, so anyways, make a long story short, I take the stuff and put it in my pocket, go walking off to the car and leave, save my son a conviction. Anyways, so I get all three of them together. My two sons, my wife, Maria, and her son the next day. I have a heart talk. I'm not going to represent you. I'm not going to pay your bond fees. I'm not going to defend you. You get in trouble. I'm 56. I've lived a very eventful life, and I've never gone to jail. And if you go to jail, good luck. Do I make myself clear at all? You got it, Dad. Next week, I'm arguing with the two of them. One says the other one stole his pot. Now I'm thinking, that just must not have been as successful as I thought it was at that time. But I'm not here to preach to you about your morals or your ethics. I'm just telling you to be thoughtful about what you do. And if you happen to have drugs, stick them hard, fast, and deep in the trunk. The law is a lot different about searching the interior of the car and the trunk. Okay? You know, if they stop you for driving offenses or whatever, the law says they have the right to search the compartment of the car. Okay? It doesn't talk about the trunk. And there'll be enough time to get out of your seat, walk back to the trunk, get your drugs out, go into where you're going, but it's not in the compartment of your car. And the one thing I do really want to tell you, and this is the last thing I'm going to tell you, and I'm very, very serious about this. All kidding aside. I'm serious. Stay away from methamphetamine and ice. That is the most vicious drug I've ever seen in 30 years. I've seen people with heroin habits. I've seen junkies. I mean, it looks like needle heaven. I've seen everything, but I've never seen anything quite like the meth epidemic which we have going on. The high you get off methamphetamine is because the house cleaning chemicals that it's made of, lye, pseudoephedrine, all these other chemicals, they're cleaning chemicals. And the high you get off methamphetamine is when it's eating the cells of your brain. And when you do methamphetamine, it eats your brain cells and they never grow back. And I have seen young ladies that are beautiful. You see their high school senior pictures and they're a sophomore in college. They've lost 30 pounds. It looks like somebody took a zip gun and hit them with BBs all over their face. I mean, their eyes are sunk halfway back in their head. They go to jail. And you know what I tell their parents? Leave them there. Don't get them out. They get out, they'll be back on it by tomorrow. Sit them in jail, and a year later they get out, and they've readjusted, and they've gone back with a life. But, I'm not telling you not to be kids. I'm not telling you to enjoy your life. I'm telling you just be thoughtful, be a little smart, and stay the heck away from that stuff because it'll kill you. Thanks a lot. To be totally honest, most of the time that I represent people, they are guilty, or at least have some degree of guilt. But occasionally you'll get a case where you honestly believe your client is innocent. I represented a grandfather charged with child molestation. And to watch the video of this 9-year-old girl, it was horrific. I mean, Granddaddy tried to do this. Granddaddy tried to do that. Granddaddy came in and he tried to open my mouth. Granddaddy tried to do all that. I mean, it was like, holy God. I couldn't believe it. And I went into this case and I thought to myself, here's a 55-year-old guy, never been in any trouble before, salt of the earth, member of the community. And I thought, I was having a real hard time defending that. But as fate would have it, the case came apart for the prosecution and he was acquitted. But I worried about that case a lot because I don't want to see anybody that's innocent go to jail. But I defend people with the same aggressiveness, the same vigor, the same determination, whether they're guilty or innocent. But obviously, I'm human, and if there's somebody that I think is getting a raw deal, or somebody's been made the scapegoat, I'm fixing to try a murder case starting a week from Monday, where I don't know if any of you heard it. There was a house down in Norcross, 2 sides of a duplex. These guys supposedly went in the wrong side of the duplex, looking to rob a guy that had a bunch of marijuana, and the guy in there got up and grabbed the bandana off one guy, knocked the gun out of his hands. They ask him what the hell he's doing in his house, and goes after the second guy, who by this time thinks this guy's an idiot. He's going out the door backwards. A shot goes off and kills him. 6 guys involved. 1 guy goes to the cops. They've never even charged him with everything, and I really honestly believe he is the guy that did the shooting, and the police have given a free pass to the shooter. And I have to defend that a week from Monday. And it's going to be a tough case, but I do the best I can to defend him, and I hope and pray that it will go well. The answer is yes, because obviously, way back when, they couldn't get blood samples, they couldn't get DNA, they couldn't get, they couldn't do fiber evidence. And yes, the technology is considerably better and it favors the prosecution. The backwash on that is that when everybody that's on the jury watches CSI or not Miami Vice, but whatever. I used to like that show. Anyways, not the remake movie, but... Well, that was before. Well, I told them it was a black and white TV. Anyways, but what happens in a lot of cases is I'll ask them in voir dire, do you watch CSI? Do you do this? Are you interested in that kind of thing? Because oftentimes, in your run-of-the-mill common case, they don't have fiber evidence. They don't have fingerprints. They don't have DNA. And you ask them, did you have DNA? Do you have this? Do you have that? And you say, no, you don't. Why didn't you? Well, you know why they didn't, because they're not going to find nothing. But the jury expects them to have it. So sometimes they hold the prosecution hostage to the fact that they don't have certain types of evidence. So in that way, it benefits me. But no, in the reality, it does solve a lot of crimes that never would have been solved before that type of technology. And the reality is most of your high-dollar people are not criminals. The only high-dollar people that are criminals are your drug dealers. Most people that are involved in molestations or murders of that are generally just salt-of-the-earth, blue-collar kind of people. Most of your murders are heat of the moment, fights between husband and wife, breaking up boyfriends and girlfriends, things such as that. So you never really know what amount of money they have. But obviously, when I set a fee, I try to figure out how long is this case going to take me to try. How long will it take me to investigate it, to go to prelims, to have bond hearings. And then I put it all together, and after having tried all these cases, I know I may charge $25,000 for child molestation. I may charge $30,000 for murder, because I know, like this murder that's coming on, I charged him less. I think I charged this kid $15,000 because he was an 18-year-old kid, never been in trouble before, and I really felt like he needed good representation. And I'm not going to make a lot of money on it because it's going to take 8 days to try. Probably go in the hole a little bit. But it was a case I wanted to try, and it was a case I felt that I could do some good for this kid. So, you try to get as much money as you can, but, sometimes it's just not there. Then you have to decide, is the case itself worth it to me to take? Sometimes I don't get paid anything. Sometimes I get paid very large amounts of money. But what I don't want is, if I agree to do it for nothing, fine. If I agree to do it for a large amount of money and don't get nothing, that's different. But I try to be honest and straight. I got a guy out of an aggravated assault case the other day, and I found myself in trying the case, and I think I got $500 out of a $10,000 fee. Of course, I haven't found him yet, but I got him off it, and so at least I got him out there so I can find him. But I was promised everything, promise him anything, give him our page, whatever, but I didn't get anything. The judge thought it was pretty funny. He said, "Well, Mr. Sliz, have a nice time in trial." I went to try and get out of the case. He said, "Nope. You announced ready, buddy. It's your case." So the business side of being a lawyer is you do have to collect your fees. I make a lot of money. I've got some incredible overhead. I've got a staff of 8, 3 other lawyers who work with me. So, it's just like a big funnel. And you have to feed it. But I don't know how other lawyers do it, but I try to figure out the time that's going to be involved and what I think the market will bear and what my services are worth. A lot of time it's not necessarily dollars per hour either. If I feel I can get somebody that's in a real serious jam out of it, it might only take a short period of time because of a 20-year relationship I've had with the prosecutor, well, I'll still charge them what I think is a fair fee because of the time and effort and everything that's gone into being able to do that. I'm a trial lawyer. I don't want to try mamby-pamby, Mickey Mouse, caca. I appreciate the efforts that my brothers in the civil field have in their skills and training, but I believe you could train a monkey to be a real estate lawyer. Bankruptcy, it's all forms. Trial litigators are trial litigators. You're out there, and I want to try the cases where I can make a difference. Perry Mason used to have Hamilton Byrd. He'd thump him every Friday. He lost. He never won. Well, that didn't happen. I came out of law school thinking, hey, all the lawyers, defense lawyers win. The prosecutors get beaten, yada, yada, yada. Well, I found out quickly that wasn't the case. So I take cases, that I can get paid a reasonable fee, and I think I can do some good. Because, I tell people, if they come in and say, what do you think you can do for me? I can hold your hand. We're in a difficult situation. But successful trial lawyers negotiate 80% of their cases. And somebody else might get an offer of 10 serve 6 on a drug case. I might get an offer of 6 do 2. Because they know I can try it, and I will take the week, and I will wear them out, and I have a decent chance of winning. Now, if you can't win the trials, you can't settle the rest of your cases. I'm going to write a book when I'm all said and done with my practice. I have to give up my bar license before I write it because I'll lose it once I tell everything. But, yeah, I've seen everything. I've seen people just start off in the middle of a sentence and break down and cry and admit they shot and killed somebody when there was no evidence about it. I've seen everything. Funniest thing I ever did, though, was one time I had a drug case, and they had a pound of cocaine in a brown paper bag. And you all are so young, but when I was growing up, Grandma would take the chicken and put it in the bag of flour, and she'd shake it around, and that's how you got the flour on the chicken, and then you had fried chicken, right? Well, it looked like we were having fried chicken. I mean, it's just going all over the place, and there's this haze in the courtroom, right? So this guy has given up. This guy is the son of a doctor, and he's given up his buddies because he doesn't want to go to prison, but it's okay if they do 20 years. So he's on the stand, and then we break for lunch. And I come back, and I'm walking by the jury stand, not the jury stand, but the witness stand, and there's this like sheen on it. So I've heard that people that separate cocaine sometimes use credit cards. So I whip out the Visa. So I'm going around the corner, and I'm digging in the corner. Anyways, I cut it all to the middle and put him a finger size line right out on the table. So we go back, nobody else sees it. So I go back and we sit down, and he comes out, gets back in the seat, and they start to talk, and he looks around like this and goes, starts looking around. And then he's going through that moment. Do I quickly dip down and take care of it, or do I just sit here and let it sit there? So he starts sweating profusely. And he's looking, and I'm just having the big soul time. I'm sitting there looking at him thinking, you sorry sack, you're putting up all your friends. And the prosecutor can't figure out what he's doing, and she finally comes up there and says, what's the problem? And he goes, so, Your Honor, could we have just a minute? There seems to be some substance on the jury. Now, occasionally when you're losing it real bad, you got to create your own humor. But I've seen everything. Just you name it. I've seen police officers' testimony change 180%. They say that the client was driving down the middle of the road and ran him off the road, and they're so proud of their testimony because they're going to put your client in jail for 15 years. And then you've got the video of the following police car where it's nowhere near the middle of the road, and he just lost control and took it into the woods. You never know what's going to happen in trial. The best prepared witnesses, the soundest evidence, sometimes just goes right out sideways. You never know what you're going to get till you're in the case. I've tried cases where I thought I had no chance to win and done well and won. I've had a case where I retried a murder case one time. Tried it the first time, hung up 9-3 to convict, went back to the judge and said, I need some more money. And the judge said to me, why do you need more money? I said, well, unless you missed it, I got 9 more people to convince. And he looked at me and he said, well, Mr. Sliz, your client's entitled to a defense lawyer, not necessarily the best. And I thought to myself, what is that? Slaps me and kisses me all in the same time. I said, well, Judge, I really do need some money for an investigator. He says, I said, I'll tell you what, Judge, you give me $2,000. Don't ask me what I did with it, and I won't ask for any more. He said, deal. So we go back to try the case the second time. We tried the case the second time, and lo and behold, my star witness got up and right out of nowhere said, I made a mistake in my first testimony. He wasn't over at my house that day when this occurred. It was the day before that. And I'm just sitting there going, what?
Was that the turtle?
Turtle case. We're a turtle case. And I have her questions. I have her answers. I'm asking the same questions. I'm expecting the same answers. And she just goes dead left of me. That one goes to 10-2 to hang up. The judge, sensing that the county of Gwinnett is paying way too much money to put this murderer in jail, they hung up at 10 o'clock. I made a motion for a directed verdict. Now, this is the second Friday of this case, 2 weeks. I make a motion to declare a mistrial at 2 o'clock, let him go home, blah, blah, blah. He cooks them to 7 o'clock that night. The other two say, enough's enough. I'm going home to the kids. Boom! My client gets convicted, off for life. I had to quit the case because I threatened the judge after in the back room, and I thought that was the same one that asked me how much money I needed for the investigation. So I thought my bar license was more important than representing this guy a third time. So anyways, like I say, it's very, very hard for me to take an hour and 15, 20 minutes and tell you all about being a trial lawyer. But the law is a great field to go into. It's you can do a lot for society, do a lot for your own sense of self-worth and achievement. And if I can be of any help to any of you, let me know. If you didn't get a packet, I have some other cards here. You're more than welcome to have one. If you have friends that do the things that I may have inadvertently accused you of, take a card. I appreciate the time to talk to you.